All prosecutions under PMLA, PBPT, as well as under Income Tax Act commence with a complaint. Now, this complaint is prescribed under Section 190 of CRPC and also in the different acts, every act, because there are two ways a prosecution can start. The prosecution proceedings can start by way of a charge sheet under Section 173 of the CRPC, where the police investigates or CBI investigates. It files a final report. Actually, the word used there is final report, which if they come to the conclusion that the offense is made out, then in that case it is called charge sheet. Otherwise, it is called a closure report. While it is the section is same 173, so that is one way of starting the prosecution proceedings. The other way is prescribed under Section 190, read with Section 200 of CRPC, where a complaint is prescribed, where there is a complainant. Here, it is the complainant of the department. Department is the officer is complainant. It could be an income tax officer, it could be an enforcement officer, it could be any officer prescribed by the board for PBPT Act, or it would be income tax officer for the purpose of Black Money Act also. So an officer files the complaint before the respective special court, and every one of these acts provides for a special court. That court is designated of a sessions judge level is designated as a special court. In case of income tax prosecutions, it is the of the magistrates court, which is designated as the special court. Provisions of Code of Civil Procedure. The procedure will be that of all the offences under the Criminal Procedure Code. That is why I have taken you to 190 and 200 for the purpose of. So all these sections say that the provisions of criminal procedure shall be applicable to all these prosecutions. Now, in the normal course, the complainant and his witnesses are required to be examined on oath by the magistrate before the accused can be summoned under Section 200 of the Criminal Procedure Code. But as the complainants in all these cases are public servant, Section 200 provides an exemption from or a discretion to the magistrate whether he wants to record the statement or not, because these are public servants. Whatever they are saying or signing, it is taken to be true, and therefore they are not examined normally on oath, and the summons are straight away issued on the filing of the complaints. Now the summons or warrants are issued under Section 204 of the CRPC. The Section 204(2) says that unless the list of prosecution witnesses filed together with the complaint, no summons or warrant shall be issued thereupon. So normally when a client receives any complaint of this nature, he does not come to us first. He actually goes to the chartered accountant. He says, "Sir, income tax ka ek aur farra aa gaya." Exactly. So he goes to the chartered accountant, and these are few things which should be seen, whether list of prosecution witnesses is there or not, or the complaint copy is there or not. It is also necessary that every summon or warrant should be accompanied by a copy of such complaint. And complaint means with all annexures. So the best thing to tell to the client is that whatever you have received, just write these many pages received. So that we can later on tell the court whether we have received the complete copy or not. Must check for annexures. Now, for a normal layman, a summon, he thinks that I can straight away go to the court. It is only a summon, it is not a warrant. Now, and I have not been arrested, but under the criminal law, once the summons are received by somebody and he appears in the court, he has to immediately, even if the offense is bailable, that person has to furnish a bond as per the direction of the judge. So that means you have to be ready with the bail bond. What is this bond provided under section 88 of CRPC is the bail bond. So even if no arrest has taken place, even if no warrants have been issued, then also the accused, whoever has received the summons, has to be ready on the day one with the bail bonds and the surety. Under the criminal law, accused has to be present on every date of hearing. In all these cases, the complainant, since he is a government officer, he is normally permanently exempted and is represented by the public prosecutor. So it is necessary that every client understands that he has to be present on every date of hearing. Even if a lawyer is not available, then also he should be present in the court, and his presence is the must under the criminal law. When one receives a prosecution notice, there are few things which have to be taken care of. Whether the complaint discloses a prima facie case, whether any legal requirements such as sanction were followed, whether sanction and summoning order were passed after due application of mind, whether material was sufficient or not, whether they were perverse, whether due procedure has been taken, or defective sanction was there. All these things have to be decided at this stage. If at all any action has to be taken, it has to be taken quite quickly. So all these things, you can't sleep. Suppose the date is after 3 months, you can't sleep over the matter. Immediately some certain decisions have to be taken in that respect. Then we have to decide whether we can challenge the summoning order in revision, or we can go for the quashing of the proceedings under section 482 of the CRPC, or we wait for the framing of the charge or notice whenever that stage comes, and then raise all the plea and then go in revision, or so this is a very, if I may say so, it is I mean, I've just taken you people through, it is the first introduction. And the whole purpose is that you should not be caught unaware.
Exactly.
You should, whenever all these things have to be in your mind. You may not become a lawyer. I'm not saying that you surrender the COP and become a lawyer. It's not that. That is not required. But it is a joint teamwork for lawyers as well as chartered accountants. Let me tell you, all these laws for normal criminal lawyers, they just cannot handle.
Exactly.
Unless as I started by saying that it is the chartered accountant who has to be work shoulder to shoulder.
Exactly.
And I normally tell people that you should remain present. You should have a control of the process. Even if you have engaged a lawyer to handle the day-to-day prosecution, the chartered accountant should always remain in picture.
True.
I always tell the client that, okay, you are not only engaging me, you are also engaging your chartered accountant for the purpose of this prosecution.
True.
So pay his fees also.
Very true.
So that totally during the whole trial, whole prosecution proceedings, both of us are there. If one of us will not be there, then the client will raise the music. Because we are not fiscal people. We don't know the fiscal law. You don't know the criminal law.
Exactly.
So this has to be a teamwork, and that is what was my purpose. I don't know for how far I have succeeded.